Welcome to FDA Imports, cross-border compliance with attorney Benjamin L. England.
Hello, everyone, and welcome back to FDA Imports Cross-Border Compliance with attorney Benjamin L. England. Ben is a former FDA attorney with over 40 years at the intersection of FDA, customs, and federal regulatory enforcement. And today we're talking about why tariff refund claims are creating new customs scrutiny for importers. I'm Sean O'Connor, and let's get into it. Ben, good to see you.
Hey, Sean, great to see you too.
I know we've talked about tariffs in the recent past, and they're still very much in the news, and sort of now moved into the refund of said tariffs. And I think a lot of companies think that the tariff refunds are basically paperwork and a payment request, but this is getting into something much deeper, isn't it now?
Definitely. So, everybody will recall most likely that Customs, the administration lost the case in the Supreme Court. That the Supreme Court found that the IEEPA tariffs, which is the ones we're talking about, these are the those that are related to economic International Emergency Economic Powers Act. So those tariffs, the fentanyl tariffs, the Russian oil tariffs, there's tariffs on China related to fentanyl, and Mexico related to fentanyl, and then also some related to Canada and Mexico for not doing enough to control cartel activity. There's a number of them. Those were struck down.
Right.
And it was the first time. It wasn't until March of this year, even though these cases have been going on for a while, that a court actually said, okay, Customs, give the money back. The problem is they said, get the money back now to everybody. And there's issues with that. I mean, part is that not everybody was in the lawsuit that went to the Supreme Court. So usually the court can't just say, give it back to everybody when not everybody was in the case. So that became a question. The other thing was Customs' reaction was, well, you say to do it now, we can't do it like now because it actually takes time to unwind it. We have to unwind it. And so they came up with a proposal to put together an electronic system called CAPE, and which means something. I'll come up with it eventually, probably
Sure.
in a break or something. But it's a system that they've added onto their automated commercial environment as a way for people to quickly, easily as you can imagine with the federal government, get your money back. And in case anybody wonders, the hardest thing probably to ever do with the government is to get your money back. And so CAPE was established. It's been tested. It actually went live in April, and people have been putting in their requests for refunds, and a very, very small percentage have received refunds. So remember, this case was in February when the Supreme Court ruled, and we're in May now. So this podcast is being recorded May 20th. So, in fact, almost exactly February, March, April, May, June, May, 3 months later, right? And we don't really have that many in the way of refunds. And in fact, what's happening is that Customs has said, yes, the system's going to be great as long as we don't have any real questions about your shipment or questions about your classification or questions. And then those cases, we will probably have to do an audit or do an evaluation. And next thing you know, only like 3% of the tariff refunds have actually been issued. So yes, it has sort of gone the way that you can sometimes expect when the government's being asked for money.
Yeah. Well, on the one hand, it feels like the fact that they got the system up and running as fast as they did is surprising.
Yeah,
Because
absolutely.
when you and I last spoke, I mean, historically, there'd been no mechanism to do this kind of a refund process, right?
So Customs has always had what's called the ACH system, which is an automated account system that they ordinarily will give refunds through, or if you file a protest and that protest money comes back, it's where you pay your duty. So there is an electronic system for that. So they didn't have to build that. They were just glomming on a module. And so in that sense, it is somewhat, I guess, simpler than sort of like starting from scratch. But I was surprised. They said they would have it done in 45 days. It was about 45 days, and it was up, and people were trying it and testing it. So that's pretty fast.
Yeah, not bad, not bad. Even in the private sector, that for that kind of stuff. But again, going forward will be the most important measure. I'm wondering, you touched on this, so if this is redundant, excuse me, but so people are filing into this new system a refund claim, right? And it's reopening old import activity. Is that because, like you just said, the uh, Customs and Border Patrol has questions about past pre-tariff activity, or is it specifically to the tariff activity?
Yeah, good question. So in relation to the recent past related to IEPA, right? So that's basically April of
Hmm.
last year, and you compare that to say the more ancient past, which we'll call March of
Sure.
last year, right? Like if you compare those 2 months, there could be that some people were changing the way their supply chains were operating. It could be that they were changing their classifications in terms of their harmonized tariff schedule, which affects the duty rate. Um, Valuation, right? How they calculate valuation, because duty is based upon the value of the goods. So when you start
Right.
changing these base numbers, you change the ultimate duty rate. Um, and so if you're looking at, rather than 25%, 145% duty, it matters if you can get your value down from 100,000 to
Yeah.
$50,000, right? That's a big
Yeah.
difference. So in March, if valuation was calculated one way, and the next thing you know, it's calculated another way in April, those are the kinds of things. That historical account is the kind of thing Customs does look at. So in a sense, yes, going back, but I think largely
Hmm.
Customs is expecting that March, you probably were doing it right, and then you're doing it wrong now. So that's where, and there's enough of these that Customs is starting these investigations and these audits, and that ties up Customs, right? It takes them time, it takes
Oh, yeah.
man hours, it takes expertise, it takes systems. And so the more time that's being spent on audits, the less time that's being spent on refunds. So all of it sort of slows the process down.
At what point does a refund review shift from being, administrative in nature and evolve into a broader enforcement problem?
That's a good question. And the answer really sort of lies in Customs ordinarily their ordinary enforcement model, which is if Customs has a question about an entry, then they'll issue a CF-28, a Customs Form 28. We've talked about that in other podcasts, and the CF-28 is a request for information. It's not an investigation. It's not even technically an
Right.
audit, right? It's just them asking for information because they see something that
There,
makes them curious.
that could be, that could be about classification, country of origin, any number of things.
CF-28 could be, it's really about anything. It can be about so when you're transmitting information to Customs, you're transmitting a harmonized tariff schedule, the harmonized tariff code. The last couple
Mm.
digits on that code are actually not Customs data. It's census data. It doesn't even
Oh,
Customs doesn't even care about it. The census is collecting it for a completely different reason, right? For evaluating trade between our country and another country,
wow.
or
Yeah.
those kinds of things, right? So it can be about that data, right? So it's anything that's associated with the import. It could be about another government agency, right? It could be about FDA, USDA, EPA, DEA. It can be about any other agency that could be asking questions about. They tend to ask questions about customs issues. And right now they're tending to ask questions that relate to duty, because that's what they're trying to not do, is pay you back. So they're trying to find ways to determine that, listen, you said this was worth $50,000 in March, and now you're saying it's worth $25,000. Explain yourself, please. And they'll do that probably with a
Okay.
CF-28, ask you about valuation and make you give all the documents. And they may ask you about entries pre-April and entries after April by this entry number and this entry number. And the difference is April, right? Which is the date when the
Yeah.
when IEPA went
Pre
into
pre
place.
tariff, post tariff.
Right, exactly.
Yeah.
Exactly. Now,
Well,
if it gets ugly, then they might go the next step, which is the CF-29.
what happens when a company is fighting for tariff refunds, but they're also dealing with, you know, FDA holds, detentions, or other CBP enforcement at the same time?
Okay, well, the tariff refunds are all historical, right? Whereas the FDA activity is
Right.
going to be current. So for instance, right now, the CAPE process is only useful for entries that have not yet liquidated. All right, so liquidation is when it's an event that occurred. I file an entry to Customs, and it says a lot of things. It's what it is, where it's from, how much it's worth, what it's used for, where's it, what free trade agreements apply, if anything, all sorts of information, right?
Hmm.
And duty is one of the things that arises in that analysis. And then after a period of time, the law wants to close the case, right? The law is designed to liquidate it, close the thing down. Once you liquidate it, then it's settled for everybody. Okay. Now, customs will do an initial liquidation, and it usually happens, less than a year after entry is made. And so during that time frame, right after entry, before liquidation, that's the CAPE time period. Your entries have to be in that category. Well, that's going to be long past entry. So FDA, USDA, DEA, all your problems there are all just your regular ongoing problems with your new entries, right? So now you got to deal with them. So you do have that
Sure.
problem. You have staff working on your IEPA piece, and then you have your FDA, people working on your FDA or your customs piece at the same time. So you are balancing a
Hmm.
couple balls. They're just not really sort of like, you're not really mixing them up.
I see. I see. What about importer of record status? Why is that suddenly becoming one of the biggest issues in these refund fights?
The assumed claimant for a duty refund would be the importer of record, because the importer of record is who
Hmm.
pays the duty. That's who pays customs. Now, it actually
Right.
gets paid in the system in ACH. Um, but the importer of record is going to be the entity in the transaction that's responsible to pay duty, and that could be a U.S. business or it could be a foreign business. You can have a foreign non-resident importer of record, and it's like you
Hmm.
could be in the UK, and you can be the
Sure.
importer of record in the United States for your entries. You would be paying the duty. You'd be paying it through the ACH system like everybody else. You'd have what's called a tax ID number, a TIN, rather than an
Yeah.
EIN, which is an employer identification number, right? But they're both IRS
Hmm.
numbers. So it matters who the importer record is, because that's usually the claimant. The problem is customs wants to know who the real party in interest is here, who really paid it,
Mm.
right? Now, many would say, well, the consumer did. I paid it, for heaven's sakes, right? You paid it, Sean. But that
Yeah.
doesn't count. Right. Now that might account in civil lawsuits. There are some civil lawsuits that are arising where consumers are suing the importers because they're not passing the refunds on. Right. Their importer
Right.
gets the refund. They got the money from me. Now they're getting a double. They're getting a windfall. And the consumer's like, wait a minute, that's my money. That's
Yeah.
not customs, right? That's civil, and it's real, and it's a real threat. We could talk about that maybe next episode sometime. But
Yeah.
in the meantime, though, um, customs wants to know whether your supplier actually paid the tariff, right? By reducing the value of the goods, right? So I'm gonna, as your seller, I reduce the value of the goods. I don't make you pay me so much, which reduces the duty that you have to pay, and I get less money. Well, that means I'm eating the tariff, and so I might be the real party in interest. And customs wants to know that. And so
Yeah.
and I'm not the importer of record, right? So, but I might have a claim anyway. I don't have to be the importer of record to make the claim. I have to be the person who has the right to the duty to make the claim.
I see. Okay. That makes sense. So you talk about, I mean, we talk about the consumer element of this, but if companies already passed tariff costs downstream, could refund recoveries trigger disputes over who actually keeps the money? I mean, that's kind of what you just mentioned, right? Where uh, on the consumer level, and I imagine it's also true within the trade, business to business aspect too, huh?
Yeah. Now, so and think about couriers, right? Think about how many goods come in arrive. I don't know about you, but there's always packages showing up on my front porch, right? And those packages come from all over the place. Sometimes they come from Georgia because there's a fulfillment center in Georgia. Sometimes they come from China,
Yeah.
right? And you can
Sure.
sort of tell. You can smell it, and you also can see all the different stickers and stuff that's on it, right? Because it
Yeah.
came
Yeah.
right out of China. And so
Yeah.
now duty was paid on that, and if it came to me, if I paid the duty, um, and I paid the duty sometimes by getting an extra bill from the carrier before they would release the cargo to me. I actually had to give my
Yeah.
credit card. Other times, it's actually calculated in the transaction. You'll see the cost of goods, you see shipping, and then you'll have the extra
Hmm.
charge. That's duty, right? In those cases, then it's not going to the seller; it's going into the transaction. So when the goods arrive, duty can be paid. Now, in the case of some of these couriers, they actually have collected the money from the consumer either in the heart of the transaction or when the goods arrive, and they are
At the
they
door.
are suing for the refunds in order to return them to the consumer. Okay, so now that's
Got it.
different
So,
than
well, so like FedEx is delivering to me something that, came from overseas. And before they'll release it, I had to give them another $80. And so you're saying FedEx is saying, hey, on behalf of our esteemed client customer, we want that $80 back because they're going to pass it back to me.
right. Right. Now
Okay.
now I don't represent FedEx, so I'm not speaking for them one way or the other,
Right.
right? Or anybody else. But I don't say that because I don't think that's what they're doing. But that's what I understand that they're saying that they're doing. All right. And they are suing customs. They're suing customs
Yeah.
for the refunds. And they are not the party in interest, even though they paid the duty. See, you're the party
Yeah.
in interest because you paid them to pay the duty. And that's sort of a good
Right.
example of it. Now, if it's not a group like that where they have very, very good tight records all the way down to you, where instead the records are to a big box store, and you walked into a big box store and you paid more for it than you would have a year earlier because it was being passed on to you. Now who do you go to, right? And so those are the questions. The consumers in some of those cases are suing the seller to them, the supply chain, saying somebody's got my money and I don't know who it is, and I want you to give it back. So very complex sort of civil question, but different than the sort of the ordinary regulatory stuff that you and I think about. But the fact of the matter is, FDA regulated goods are probably some of the most litigated goods that you can find. Think about foods, drugs, medical devices,
Yeah.
cosmetics, right? I mean, that stuff
Yeah.
ends up in lawsuits sort of all the time. Not because the stuff's bad, just because there are just real risks associated with those kinds of products. They're just real.
Yeah, interesting. One last question here for our episode, just because time is more or less running out. I'm wondering, speaking to importers, right, out there, they're preparing refund claims as we speak. What should they review internally before submitting anything to CBP?
They need to do a self audit. Is what they need to do, and that's what we do. We do that for our clients. Our clients come to us, whether or not we're suing the government on behalf of a client, or if we're just helping them with protests, or we're helping them with the CAPE process. We help with all the different steps, and sometimes we help with all the steps, literally, for the same client. And one of the things that we do is as long as the client is willing for us to do it, is to do these audits and do what customs would do, because we want to go in with our eyes open. We want to make sure that the claim we're making is legitimate, and we also, if it turns out that somewhere in the supply chain something happened and someone said something that made its way into the entry that happens not to be correct, and I figure it out and it has an impact on duty, it doesn't matter that the duty shouldn't have been collected. Think about that, right? In other words, like someone would say, well, who cares? I paid less IEPA duties and the IEPA duties were illegal. It doesn't work that way. You have to say everything that's correct in the entry. You don't get to sort of prejudge the IEPA duties and then just pay less of them thinking they're going to be considered to be invalid, right? Just doesn't work that way.
Got it.
So you got to figure out if maybe you've got a disclosure issue. You should prior disclose to customs the situation and say, I think I might have an issue. It turns out, of course, the money would be coming back to us, but we don't want to go into this and leave you with the impression that we're trying to hide anything. We just discovered it, we're going through, et cetera. So the audit that might lead then to a prior disclosure, hopefully in advance of a CF-28 and certainly in advance of a CF-29. If you get that far, your prior disclosure doesn't help you in terms of penalties. So important stuff. Important stuff.
Yeah. Well, I love that. Yeah, I mean, just do that due diligence. Pretend you're subject yourself to an internal audit. So avoid those surprises. Well, that's awesome, Ben. You don't hear this very often, but that's a very interesting conversation about tariffs. Good to see you.
Well, I try to make it understandable and sort of like take away some of the technical pieces of it and still be correct. And if I mess something up, let me know. I'll be happy to correct it. But come to FDA-Imports.com.
I'm sure someone will let me know. It's the internet. I'm sure someone will let you know you made a mistake if you did.
Indeed.
But I'll talk to you again soon. Thanks again for your expertise and time.
Great. Good to see you, Sean.
That's it for today's episode of FDA Imports Cross-Border Compliance. Visit FDAImports.com to learn more or to connect directly with Ben and his team. Thanks very much for listening. And don't forget, subscribe, share a link to a colleague, maybe even leave a review so more importers and trade professionals can stay informed. Have a great day. I'm Sean O'Connor.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.